versus Platinum Equity, LLC.
Good afternoon. May it please the Court, my name is Robert Levine. I represent Leonard Lichtenstein in this workers' compensation appeal, and I'd like to reserve 3 minutes for rebuttal. The gorilla in the room, if you will, which I'm going to get the question, I'm sure, is, Mr. Levine, why isn't there competent substantial evidence in this record to support what Judge Jenkins decided?
You beat me to it.
I thought I would. The answer is that we look first at what the judge relied upon as a basis for our order. One was what was represented physically as opposed to orally or in writing to the doctors, and one was what was represented verbally to the vocational experts. Now, Judge Jenkins did not have the advantage of the, and I'll pronounce it, de juste case that I believe Judge Padavano was on, and we may differ, and Your Honors may ask me questions about it, but I'm convinced that based upon de juste, the parts of the bases on the doctor's belief on what they saw, there was no written or verbal representation. So I'm going to focus on the tougher part of my case.
Dr. Patterson, I think that's his name, testified
Yes, sir.
that the claimant's activities on the surveillance tape were outside of the scope of what the claimant told him, the doctor, the claimant could do.
As I read the order, the record, Your Honor, and perhaps I'm wrong, but as I read the record, it was not what he said, but what he presented. I think the word was presented, and I could be wrong on that. If I am, I apologize to the Court.
I will verify that. My memory was that it was.
And when I looked at the record again this morning, I believe it was presented, which is typically what doctors say. Now I'm going to focus on the part of the case that was most troubling to me as I wrote the briefs, and that is the representations made to the vocational experts. Now, what I'd like to analogize, first start with the understanding that differences in history are not necessarily misrepresentations. I'd like to analogize about how lawyers, for example, will suggest to their clients how a witness on a stand should answer a question. Let's assume for the purpose of argument that my client's been hit in the head 11 times. There's several ways I can ask my client to present that. One is I was hit in the head 11 times. One might be I was hit in the head almost 12 times, almost a dozen times, a dozen maybe being more influential. One might be I was hit in the head more than 10 times. Each one of these has to do with 11, but each one is a different statement. They're not necessarily misrepresentations. And here when we look at, and Judge Jenkins very carefully made a comparison of what was told to Mr. Orphanides and what was told to Ms. Panaccio. And as I went through it in my initial brief, what we see here is essentially a distinction between qualitative and quantitative. Quantitative differences, in my mind, are not misrepresentations. A difference in qualitative, factual difference could, in fact, be an incorrect statement. Now, as I go through the distinctions, which are so-called clear inconsistencies by Judge Jenkins, I really see only one that qualifies as a qualitative difference, and it's in the order. That one is that Mr. Lichtenstein told Mr. Orphanides that he only occasionally climbs stairs, and he told Ms. Panaccio that he hasn't tried it yet. Now, I'm not sure that's the type of factual inconsistency that rises to a misstatement or misrepresentation. But if it is, it is. However, there are two parts to this test. The second part is intent. And the judge must determine whether Mr. Lichtenstein did this apparently factual misstatement to Ms. Panaccio for the purpose of obtaining workers' compensation benefits. She said he did. But what's interesting about this, and one of the things that we see sometimes after the briefs are out, is it is backwards. Let me explain. If you look at Judge Jenkins' order, Record 769, the 13th page, what she says is that my client made more favorable representations to Ms. Panaccio than to Mr. Orphanides. that would be backwards, because if my client is making a misstatement in his favor, or excuse me, if it was in his favor, that would be one thing. In this instance, it's really hurting his case to tell Ms. Panaccio everything that's more favorable, meaning this. He's essentially saying, according to Judge Jenkins, that here are the things, Ms. Panaccio, that are bothering me, and they make me more able than what I told Mr. Orphanides. I'm more able than that. Therefore, I want you to help me be less able or permanently totally disabled. So when it comes to intent, the second part, in the competent substantial evidence question, it really comes down to where in the record does it make any sense that my client would make the single qualitative, factual misstatement to his own expert for the purpose of getting workers' compensation and try to make himself look healthier. It makes no sense. Really what we're doing here is coming back to the smoking gun. The proverbial smoking gun in this case is that surveillance video. It's good video. I'm a defense lawyer by trade most of the time, and I'd love that one too. However, we're told that Mr. Lichtenstein, because of his years in workers' compensation, is a sophisticated guy. We're also told, basically, that as a sophisticated guy, he should know how to commit fraud. And then we're told that he's clumsy the whole way. Most of the cases, for example, the Areola case that was decided in August of this year, very recent case, when we talk about intent, we're talking about one thing. That case was a false Social Security number. Judge Padovano recalls disuse was use of a cane or not use of a cane. Here, my client, supposedly being sophisticated, lied to all of his doctors, misrepresented to both vocational experts, misrepresented to opposing counsel in a deposition, also misrepresented to the judge. Truth of the matter is, really what's going on is the following statement by the judge. How is it possible that you don't believe that a riding lawnmower is yard work? That's not credible. It's incredible. And you know what? I might even agree. But you know, and I don't mean to step on anybody's faith, but I have heard in public and in the courtroom, I've heard people say that it's okay to murder and be absolved by going to confessional, and that's fine. And that's the way they think. In this case, perhaps Mr. Lichtenstein thinks that riding a lawnmower is different than the two people who were climbing ladders and doing the rest of the yard work. But the fact is, that's not a basis of the judge's order. Moreover, what the judge said was that that makes Mr. Lichtenstein not credible. Now, being not credible has to go with the weight of the evidence. It doesn't, however, create a misrepresentation. So here's what we're down to.
Counsel,
yes, sir.
My memory is that didn't he say something in a deposition?
He did.
That could be the basis for a false statement?
Yes. Yes. And in fact, that was not the basis of the judge's order, nor is that really what our review thing. Yes, he said in the deposition, I don't do yard work. He basically contradicted what most of us believe we saw in the videotape. I agree with that. However, again, that wasn't the basis of the order. It's not something that Judge Jenkins was looking at. And really what she said is, this is not credible. Maybe my client is not the most credible witness in the world. I get that. He's going for permanent total disability. He's relying upon expert witnesses such as Mr. Orphanides and Ms. Panaccio and the doctors and his attorney. And if the judge says, well, he's not credible when it comes to permanent total disability, then the fact that he's on the riding mower may have something to do with whether he's able to work or not. But is it a misrepresentation? I don't think so. And more importantly, when he says, I don't consider that yard work, what the judge didn't say, that's a misrepresentation that I'm using. But Judge Van Wart, I can understand where you're coming from. Now, when we get...
Did you reserve time for rebuttal? I didn't write it down.
Yes, 3 minutes, so I have about 3 to go. I'll go briefly to the permanent total disability portion of our program. And the permanent total disability is troubling because this court has before said that it's not up to the employer carrier to go ahead and stop benefits. Well, factually, what happened in this case is they smelled a rat, and they sent him to a psychiatrist, Dr. Pandya, and they wouldn't authorize treatment. They also, according to the record, would not further authorize treatment by the pain doctor, Dr. Miguel. So then what happens? We go on permanent total disability, go, here's the smoking gun, we got the video, let us off the hook on everything. But Judge Jenkins relied upon Mr. Orphanides, and Judge Jenkins didn't look at the psychiatric evidence at all. Not at all. Mr. Orphanides did. And when Mr. Orphanides was presented with the psychiatric evidence on the permanent total issue, what he said was, if Dr. Pandya has him off work, then no, he's not employable. That's not in the order. No consideration of the psychiatrics in the order. So here's what we've got. We've got, number one, the EC decided that this gentleman was a fraud. Number two, they refused to authorize 2 doctors for treatment that was needed. Number three, judge sees a video, judge ignores the psychiatric status. The judge then relies upon Mr. Orphanides, but ignores his opinion that based upon the psychiatric, this man is not employable. And then finally, we get to the answer brief where there's no mention of Mr. Orphanides at all in the permanent total disability section. We then have a quote from the answer brief where there's some suggestion that, yeah, Judge Jenkins understood what the psychiatrist really, the problem was he didn't get an accurate history, just like with everybody else. Well, are we going to sweep this under the rug? I think there is evidence for both sides. I think the judge made an error, first of all, in forgetting about the psychiatric or ignoring Mr. Orphanides says not employable if that's a psychiatric work status. The judge did not have the advantage of the DeJuice case at the time, which I think takes out the presentations to the doctors. And then we have one single factual distinction qualitatively. Climbing stairs, haven't tried versus I try not to. Without proof that, reasonable proof, that there's intent involved, because when he said to Ms. Panaccio, gee whiz, I haven't tried it yet, he was really making himself look healthier, according to the judge. It's backwards. Now, I'm going to reserve the rest of my time, but I wonder, and perhaps it's a question to ask opposing counsel, why is it not appropriate to at least remand this case on the psychiatric issue, on the permanent total, or to say to the judge, what were you thinking when Mr. Orphanides said not employable? Why didn't you say something about that? I'll reserve the rest of my time. Thank you.
John Darren, appearing on behalf of the appellees, Your Honors, pardon me. Counsel argues that there is no more to this than physical observation and what was told to the experts in order to fit the case within DeJuiced. But in fact, I think there's a lot more to it to that. If you simply look at the DeJuiced test, there have to be oral or written representations. In the instant case, this gentleman, who was a 30-year telephonic case manager, very familiar with the comp system, signed not one, but 2 petitions affirming that he was unable to engage in any employment requiring physical labor. And then we have the videotapes, which he admitted were him in court, showing that he was doing shoveling, he was carrying a large container of debris, he'd applied weed killer, he had applied fertilizer, and much to the judge's dismay, in a Clinton-esque sort of a fashion, he said, well, what is lawn work? I'm not sure that all that constitutes lawn work, or riding a lawnmower. But then we have the actual statements to the doctors involved in the case, because that would be required under the DeJuiced ruling. Mr. Lichtenstein told the doctors that he couldn't touch plastic. It sent shivers up and down his spine. And on page 3 of my reply brief, I've cited line and verse. But then we have these videotapes of him, in fact, holding plastic bags at Publix, helping his wife out in the parking lot. He also told the psychiatrist, Dr. Pandya, which was in the record, that he had continuous, every day, 24 hours a day, pain in the arm, neck, shoulder, and fingers, which was contramanded by the videotape, or shown to be false by the videotape. He told Dr. Patterson.
Let me try to understand that. How did the videotape show that he was not in pain?
It showed that he was capable of touching plastic, contrary to his statement, Your Honor.
I understand that statement, but what if you said he testified or told this person that he was in constant pain, and the videotape somehow showed he wasn't in pain? It may have showed he was doing activity which might be difficult to do while you're in pain, but I don't know how it could prove that he made a fall.
Your Honor, you are correct. There was no obvious discomfort, but you're right. The videotape could not prove that he wasn't subjectively in pain. That's correct, Your Honor. He also told the psychiatrist that he had continuous pain 24 hours a day in the arms, neck, and shoulders, and he could not do any work, which in fact he was shown to be able to do shoveling and the other things. And this segues into the permanent total disability claim, because as this Court has pointed out in other PT appellate cases, you look not only to whether or not they're capable of doing sedentary work on an uninterrupted basis under 440-15, but you look at their vocational background, their educational background, and in this particular case, all this gentleman has to do is basically sit or stand at a desk and act as a nurse and maybe question doctors, maybe handle the medical aspects of a case, but he's got very little physical work to do. He also...
I want to make sure I understand, because I raised this when appellate's counsel was arguing. Did the claimant make a statement to one of the doctors about his inability to do work, or did he present to the doctors and the doctors concluded based on his presentation that he couldn't do work? It seems to me that's crucial under the JUICE.
In the record, volume 3 at page 577, Dr. Patterson testified, and I'll quote, he describes that he cannot use his arms well. He has difficulty doing anything using his arms on a prolonged basis. He can't hold up a paper for any length of time. He walks, but states that he does no other kind of activities, that he would simply do some walking, but was not involved in any other type of activities, such as shoveling, such as riding a lawnmower, and that any stimulation of his arm would cause it to immediately be painful. He couldn't open a door with his right hand. He couldn't open a door with his left hand. And he says that this is what the patient described to him. Likewise, oral statements to Dr. Pandya, the psychiatrist. He has continuous, everyday, 24-hour-a-day pain in the arms, neck, shoulder, and fingers. I don't think that was an objective finding by the doctor. I think that's what he was told by the doctor. That's pretty much my presentation, Your Honor. Any questions?
To me is key, is to the extent the record reflects that there was a statement made versus an observation by the doctor.
I think there is competent and substantial evidence of record within the doctor's depositions. And also, Your Honor, I think the signing, the actual signing, not by an attorney, but by the person himself, the appellant of the petitions, indicates that he's incapable of any physical work. That was his statement.
And you think the signing of the petition is sufficient, and the allegations in the petition are sufficient to satisfy the test that we've now adopted and deduced?
I'd use them combined with the oral statements to the doctors, Your Honor. I wouldn't just bank on the petition, but I think it's one more brick in the wall. Thank you very much.
May it please the Court, once again, I do want to address the petition for benefits issue for two reasons. Number one, it wasn't presented below. But number two, that's an awfully slippery slope, because essentially any time a claimant brings a petition for benefits for permanent total disability, if they don't prevail on permanent total disability, then essentially they would have committed fraud, which I don't think is the intent of the fraud statute. I think you're allowed to make allegations or position statements, and I think that's what was done. But again, it wasn't ordered below, wasn't discussed below, nor was the plastic really part of what Judge Jenkins relied upon. The plastic was only referenced in the order about a history given to Ms. Panaccio. And now, all of a sudden, we're hearing about Dr. Pandia, which, interestingly, is nothing that Judge Jenkins spoke anything about. Now, Judge Van Norwick, you heard what is perhaps the sole record statement. And I would argue to you that that is not an inconsistency that creates a misstatement, but rather that is one of the, is it 11? Is it almost a dozen? Is it more than 10? Meaning that the quantity of one's pain will change from day to day. Whether one is not telling the truth is a wholly different issue. If indeed the judge is looking at this one statement by Dr. Patterson as a basis of her order, then again I ask, where is the evidence of intent upon which the judge relies? Where is a reference anywhere that says, obviously, in saying this to Dr. Patterson, he intended to do something? Because that's, again, the Areola case, and which isn't, I don't think, revolutionary in terms of a judge has to make a determination about intent. And we say this is the so-called fraud defense. Well, really, I think it's kind of becoming the fraud defense because we need an absolute statement and we need intent, and that's pretty close to it. Now, if Judge Jenkins had the opportunity to do this again, I don't know whether she'd do the same. I know her well, as I imagine your honors do. She's nothing if not a bright lady. And I know that when she comes up with a ruling that the court disagrees with, for example, the Bob Wilson Dodge versus Muhammad case when she was a new judge, she was very bothered by that. Here she didn't have the opportunity to see dejuice. So that entire part of the order, in my opinion, is out. It's fatally flawed. So we're left with, again, one single misstatement, and here's what we have. An elderly gentleman who has had 6 surgeries, who has pain implants, and he's picking up dog poop in his yard, and granted he's riding a lawnmower, but he hires other people to do the rest of it, and for that, we're not only going to deny that he gets no money benefits, but that he gets no medical care for the rest of his life. Your honors, I don't think that's right. I don't think it's supported by the record, and we respectfully request reversal. Thank you.
Thank you, counsel. Thank you both.